All right, welcome everyone to the Women's Business Center and our webinar for, it's April. Gosh, did we all file our taxes? I think we did, right? So everyone's relaxing and celebrating and spring has sprung. And our topic today, if you filed taxes, might still be on your mind. Today we're going to talk about the difference between employees and independent contractors. And this whole webinar is really going to address what you need to know as your business grows. And we are so glad you are all here. Whether you are an independent contractor, an employee, own a small business and want to grow it, or you're just even thinking about starting a business, these webinars are always useful and helpful for everyone who attends. So once again, welcome. And the webinar is brought to you by the Women's Business Center at Jedi. Plus, we have two wonderful co-sponsors this time. One being the SBDC in Shasta Cascade. So shout out to Joe and the crew down there. Thank you so much for being a part of promoting and producing this webinar. And also West Women's Business Center in Mendocino, which is how we met our presenter. And so shout out to Marianne and the team over there. As you all know, the Women's Business Center, as well as SBDC and West, we are here to help you start and grow businesses. And we offer all sorts of training and workshops and free tax prep and private consultations, loan application assistance, as well as advanced business development. So we're here to help economy grow, to build wealth creation in our region. Next, I just want to give you a couple heads up on how to make the most out of this webinar. So we do use the Zoom platform. I'm a big fan of Zoom. I love it. If you look down below, usually it's below, depending on your computer or tablet, you have the opportunity to chat. So if you're interested in chatting, in the far right is the chat section, or it'll pop up in your screen, but ask questions. We are going to be able to get those questions answered at the end of the presentation. I'm going to be keeping track of the questions. I always like it when people put a big Q as in question and then type it. If you have comments, you're welcome to put those in the chat as well. And we're going to have a couple polls today. So stay alert, take notes. This is going to be meaty information, but we also have some resources that are going to be available to help you as we go through, make good decisions around employees versus independent contractors. So enjoy, apply this to your business or your future business or your visions. And I think now I get to introduce Lisa McCormick. And so first off, Lisa, hi, we see you right now.
Hi, everybody.
And where are you coming in from for the benefit of everyone?
I am in beautiful sunny Mendocino. And so sunny that I have to have my blinds down. It's great to be here.
Cool. We're really happy to have you and your expertise and experience. So you, Lisa, have spent over 30 years as an HR practitioner and leader. That's so awesome and impressive. I'm going to read out her bio for us all. Lisa has spent over 30 years as an HR practitioner. She is the co-founder of Affogato HR Consulting. And much of her experience has been in high technology, working with small companies undergoing rapid growth and change. Working for highly successful organizations such as Intel Corporation and numerous venture-backed startups has resulted in a pragmatic approach to problem solving and conflict resolution, which produces practical solutions and effective results. And I bet a bunch of stories too. Huh,
oh, Lisa? Yeah, of course.
All right, well, take it away. We're glad you are here.
All right, very good. Hello, everyone. I'm going to actually take my video off so that I can do a very good job of presenting this information to you today. And thanks to Joy and the Women's Business Center for inviting me to speak with you about this topic. I've been speaking about this topic quite a bit since last April, and we'll talk about why. And as Joy mentioned, I've been practicing HR in California for, excuse me, well over 30 years. And every year, we are faced with new employment-related laws. And typically we have some insight into when these laws and regulations will go into effect, maybe the first of the next year, and we can get a little bit prepared for it. But last April, we were somewhat blindsided by a California Supreme Court ruling on independent contractors. And there was no warning. It was effective immediately and retroactive, a new, more stringent test for independent contractors in California. And I promise that we'll get to this new ABC test, because I'm sure that's why a lot of you are here. But before we do, I think it's important to talk about who does the work in an organization, because workers come in many shapes and sizes, and understanding the differences is really key to making the right decision on how to classify a worker. And I always have to say my disclaimer, I am not an attorney. And you should always consult counsel when you're making decisions related to employee classifications, and always ensure that you have the most up-to-date contractor agreements and offer letter templates and all of those things that will help you stay in compliance. So we will move into, oh, that's nice. My slides are not advancing. Here we go. We'll try a different way. So before we get into the agenda, I'd like to know who is here today. So Joy, if you could launch our little poll to get an idea of who actually is on the call.
All right, so this should be popping up on your screen, and if you can answer the question. Are you a sole proprietor? Are you an employee? Okay, I know it takes a little time to read the choices. Perfect. Looks like we have about 2/3 of people have voted. Oh, we're hitting the 3/4 mark. I'll just give us a little more time.
It looks like we have a good
distribution.
distribution.
Yeah. Well, you guys are all probably wondering who is here. I know Lisa wants to know. So I'm going to go ahead and share the results with all of you. And it looks like most people, well, 4, which is 31%, are sole proprietors with no employees.
Okay.
All right.
All right, great. Thank you very much. That is very helpful. And are you closing the poll, or is that something that okay, there we go. It closed. Okay, very good. And you, if for those of you on this, you can move around that polling box. I noticed. So if it's blocking a slide that you need reference to, you will have some flexibility there. So thanks very much for that. So moving on to our agenda. Well, I'm sorry about this. My mouse is a little fast today. So I'll begin by talking about the way we work as businesses today that really challenges how we hire and manage workers. And then we're going to move into reviewing the different types of workers. Here we'll review the new ABC test for independent contractors, and we'll walk through a few scenarios where you will get to decide contractor or employee status. And then I'll spend just a few minutes on what you're required to offer in terms of benefits to employees. And then I'm going to share with you part of a chart that we'll provide to you after the webinar that shows what state and federal laws you must comply with as an employer based on your size if you have employees. And then we'll move into Q&A. So let's begin. So let's talk about how we work today. So the gig economy versus employment laws from the 30s. So it's really interesting how the landscape has changed related to employment and how we work. We continue to be challenged as employers by having to live with employment laws that were actually put into place in the 1930s. And these were great laws, right? They were laws made to protect workers, things like the 40-hour work week and overtime pay, meal breaks, some of those things that didn't exist back in the 30s. And while some of these laws have been amended over time, they're still not close to being current with how businesses work today. And this continues to evolve. What's the gig economy? So today's businesses don't want to just hire employees. They want to use freelancers and on-demand workers to do the work that an employee may have done in the past. Things like low employment, shortage of workers are requiring employers to find workers wherever they can. And that has been described as the gig economy. Next, technology. When are you not working? How many of you have your work email on your smartphones? How many of you, if you have employees, allow your employees to have their email on their smartphone? When are you not working? What about checking email during vacation? I'm sure, most of you, especially as business owners, do that. So how can we comply with outdated labor laws when everyone has smartphones and technology and social media and all of these things? So this has definitely created challenges for employers. And then, flexibility. So a lot of younger workers, and not just younger workers, workers today want flexibility, and especially millennials, they want to travel, they value time away from work. So a lot of today's startup companies want to offer things like unlimited time off or flexible time off, where you take as much time as you want off. You're not accruing and formally tracking vacation, and this practice definitely has its pros and cons. So these are some of the ways that we work today that's really created a lot of challenges for employers, and that's going to continue to happen. So who does the work? So there are many people that do the work. First, we have employees, and we've all been an employee probably at one time or another. They come in different shapes and sizes, regular, temporary, full-time, and we're going to talk about that. Then we have interns, which are a special type of employee. They could be paid or unpaid, and we'll go into detail about that. Volunteers, I'm sure most of you have been one of these, or maybe probably are still today. I know I am. And then independent contractors. And there are other people that also do work for your organizations, vendors and partners, but these are the four that I think are the most important to talk about. So let's move into the first one, which is an employee. So what is an employee? What do you have to do if you have employees? Well, employees must be paid at least minimum wage in the city and state where they work. So if you have employees that are working in multiple cities, they need to be paid minimum wage based on the city where they are working. Minimum wage in California currently is $11 for employers with less than 25 employees and $12 for employers with over 25. And this is going up each year in California until it reaches $15 an hour in 2023. And also keep in mind that many cities in California have their own minimum wage. San Francisco, San Jose, for example, are $15 an hour. So where it used to be good enough to know what the state minimum wage is, it isn't anymore. And these minimum wages, as most of you that are employers probably know, have been going up on a regular basis. Employees are subject to wage and hour regulations and other state and federal employment laws. Employees can be paid hourly, and if they're paid hourly, they are subject to overtime regulations. They can also be paid salary, which we say is exempt from overtime. Some of you may have heard that term, exempt, but must meet exemption tests under the Fair Labor Standards Act, which is not easy to do, and must be paid at least 2 times minimum wage, which would be $43,680 annually in California. So you have to be careful. You can't just pay somebody a salary to avoid paying them overtime. So those are important things to know. And also employees are subject to some mandatory benefits, which I will review. So employees come in different shapes and sizes. So regular employees are hired for an indefinite time, and temporary employees are hired on a temporary basis, maybe based on the length of a project or if there's an increased demand in your business. So there's no hard rule about how long you can keep somebody as a temporary employee, but but I have been advised by counsel, when you really hold their feet to the fire, they say no longer than 6 months. And keep in mind, this is a temporary that you're putting on your payroll. It's a little less risky when you hire a temporary through an agency because you are not the employer of record. But in any case, it's important not to keep temporaries for a long time, because after a while they start feeling like they are regular employees and you're not giving them the benefits and a lot of the other things that a regular employee would get. So that's something important to keep in mind. Employees can be full-time or part-time. There's no single legal definition, but 30 hours a week is becoming the common standard for full-time. Full-time employees generally work between 30 and 40 hours per week and are usually eligible for all the benefits that are provided by the employee: time off, excuse me, health benefits. Part-time employees generally work less than 30 hours a week, and they may not be entitled to all of those benefits, but there are some mandatory benefits that that you will be subject to provide for part-time workers. Interns. So interns are people who come to your organization to work as a trainee in an occupation or a profession to gain practical experience. So they're really there for them more. They're there for them, more for them than they are for you. Interns can be paid or unpaid, and if they are paid, they are employees, and they would nearly always be considered hourly, non-exempt employees who must be paid at least minimum wage and overtime pay. And I will come back to this after we talk about unpaid for a minute. So if you bring an intern on and you don't want to pay them, they need to be either a student receiving college credit, or the training is for the benefit of the student or trainee, and the employer gets no benefit, and in fact may actually have operations impeded at time. So you're not paying this person, they're not an employee, you're doing this for them, and your benefit would be minimal. If you feel that you want to get some kind of benefit out of an intern in addition to giving them this training, then you need to pay them because they are an employee. Trainees do not displace regular employees, but work under their close supervision. There's no expectation of a job at the end of the training period. And the students and trainees are not entitled to wages for the time that they spend in training. Volunteers. So volunteers are not employees. A volunteer is a person who performs a service willingly and without pay. If you are a nonprofit, you could not survive without volunteers. Nonprofits, public service, religious, humanitarian organizations, people who volunteer are not expecting pay, and they are not employees. However, if you are a for-profit entity, people who work for you are generally employees, and you must comply with laws. If somebody offers to work for nothing to gain experience in the field, they are not a volunteer, they are an employee if you are a for-profit entity. So for-profit entities really don't have volunteers. So that's important to understand. And volunteers are very important to a lot of our nonprofit organizations here in the county. So what are these mandatory benefits that I'm talking about? So if you have an employee, there's some things that you have to do. You have to provide workers' compensation insurance in the event that they are injured on the job. Unemployment insurance, so you have to pay into unemployment insurance, Social Security, and Medicare. So these are what we generally refer to as employer taxes. You also need to, in California, provide paid sick leave, and this is for part-time and full-time employees. Full-time employees, it's 3 days per year of sick leave or 24 hours. You can give that in a lump sum upfront, or you can use an accrual method, which would be 1 hour for every 30 hours worked. This is something that you have to provide. It is mandatory in California. You also need to allow for the employee to pay into state disability insurance. So that's another tax-related thing that comes into having an employee. And time off is not mandatory. Things like vacation, holiday, PTO time, aside from paid sick leave, you're not required to offer those benefits. But of course, it's something that is typically expected, and it's a way to attract and retain employees. All right, so let's move into our next category, which our last category, which is independent contractors. So an independent contractor is a self-employed individual, business, or corporation that performs a service for an employer under an agreement. Now, that's agreement or a contract, right? That's what independent contractor is. This individual is working under a contract. They're not subject to the employer's control or right to control regarding the method and means in which the service is performed. Independent contractors retain control over their own schedule, the number of hours worked, jobs accepted, and the performance of their job. So keep in mind, these are things that are all outlined in the contract, right? So it's about delivering what is in the contract. So they have control over their schedule and hours. They may have a major investment in equipment. They typically furnish all of their own supplies. They have their own insurance. They pay their own employment taxes and their expenses. So continuing on, they may also perform a special service that is not in the normal course of the business of the employer. And contractors have a contract specifying terms of work, so termination of the relationship must follow those terms. So unlike an employee who in California, you could terminate at will, you can't do that with contractors. If a contractor decides to stop working with you, they would be in breach of contract. If you terminate them and not follow the contract terms, then you would be in breach of contract. So that's something very important to understand and a big difference between contractors and employees. All right, so let's talk about the actual determination process. So the old way, so before April 30th of last year, California and also the federal government and the IRS used what's called a common law test. It was called the Borrello Common Law Test. And it had a lot of factors, and it still does, actually. The IRS still uses it. At one time, the IRS had a 21-factor test, and then they condensed that down to an 11-factor test. But there are a lot of things to consider under the common law test. And the first and always the primary factor, and still is today, is the nature and degree of control exercised by the employer. So you're going to look at that. The extent to which the work is integral to the employer's business. That was another factor that was considered. The relative investment in equipment by the worker and by the employer. The extent to which the worker was engaged in a distinct occupation or business. This is still very important today, and we'll talk about that in the ABC test. They looked at other things like profit and loss. Did the independent contractor or their business have an opportunity for profit and loss based on how they manage the business, which is always a very interesting and difficult one to understand. And there were others, length of time, method of payment, all sorts of things that were considered under this common law test. And, it's never been easy to make these determinations, and it has resulted in a lot of contractor misclassification. The good news is that the new ABC test only has 3 factors. The bad news is that they're not as easy to meet. So let's take a look at that. So on April 30th, the California Supreme Court adopted a new test for independent contractors that generally assumes that workers are employees. So we're starting out that workers are employees unless ... And this came about based on a case, Dynamex Operations West. And in the Dynamex case, the California Supreme Court rejected the Borrello common law test for determining whether workers should be classified as employees or contractors. So Dynamex is a same-day courier and delivery service, and their drivers had been classified as employees for a long time. And in 2004, they decided to make their drivers independent contractors. And it was basically to save money. Eventually a driver brought a suit forward claiming that the drivers should be employees. And that's how this whole thing started. This new ABC test, as a result of Dynamex, only applies to contractors in California. So if you are working with a contractor that is not in California, you need to understand what that state's test is. It probably won't be as strict as California or Massachusetts, because this ABC test in California was modeled after Massachusetts statute, which is the strictest in the country. So right now, at least from what I know, California and Massachusetts are the strictest, but I don't know what these requirements are in every state in the country. So you need to make sure that you understand that if you're going to hire a contractor outside of California. Okay, so let's dig into the ABC test. The ABC test considers all workers to be employees and permits workers to be classified as independent contractors only if all three prongs of the test are satisfied. That's where the ABCs come in. So A, the worker is free from the control and direction of the hirer in connection with the performance of work, both under the contract of such work and in fact. So this is not any different than the Borrello test. Control has always been the primary factor, and it continues to be. So this isn't new, and this isn't as difficult to meet. B, the worker performs work that is outside the usual course of the hiring entity's business. This is the ouchie. This is the new twist. This is where everybody is the most concerned, because you have to really look at this carefully. If you've been using contractors to do work that you have employees do, and maybe it's slightly different, but it is in the course of your usual business, you will fail on the B prong. So we're going to go through some examples of this to help you understand it better. And then C, the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work that's to be performed by the hiring entity. So this also is something that was under the Borrello test, right? You needed to show that you had an occupation, a business, customers, that you had been in business for a while, and that you were doing this kind of work for others. So A and C, not so different. B, definitely providing a lot of challenges for us. So I'm going to take just a breather here and let this sink in.
That's good, Lisa, because I've got a couple questions coming in.
Great.
Okay. First off, these slides as a PDF, are they going to be available?
They absolutely will be available to everybody.
Great. And then also just letting people know that we will send you a replay of this webinar so you can re-watch it. Okay, so then secondly, what happens if you are the only contractor and there are no other employees? I'm not sure I understand the question, Hilda. Lisa, is that enough information for you?
No, I don't understand the question. It may be if you're the only contractor working for a company that doesn't have employees, maybe that's what she is asking.
And maybe that applies to B. Yes, and she's saying yes.
Yeah, so well, it depends on what the business is. So, for example, if you are if the business is, let's say, a graphic design company, right? They're a graphic design company, and the owner, say the owner of the business, right, does graphic design work, and they need somebody to help them do graphic design work, and they hire an independent contractor to do work. That is a problem with B, right? Because that is not outside of the usual course of the entity's business, right? They're a graphic design company, right? So this is where everybody is getting concerned. It's like, well, I'm a sole proprietor, or I'm a one-person shop, and sometimes I get too much work and I need to bring in a contractor to help me. That is a problem. Under this ABC, that is a problem.
So Lisa, one thing that comes across our WBC Center a lot is something, people often hire independent contractors to do their marketing or their social media, or maybe
Right.
their content blog writing or proofreading. How would you advise someone who is wanting to get independent contractors involved in their marketing efforts?
That's actually not a problem, because that is not, your core business is not marketing, right? If your core business was marketing and you hired somebody to do marketing for one of your clients, but if you're hiring somebody to do a service for your business, an HR consultant, a marketing consultant, that is typically fine, right? Because that is not your business, right? So in the example that I gave about the graphic designer, hiring a graphic designer, that is your business, right? So that should be an employee. Or you need to work with, if there's some very special skill set that maybe you don't have in your organization, you might be able to use a contractor, but you need to make sure that it is a contractor that, and we're going to talk about this in the next slide, that maybe works for a larger organization that is actually paying that person as an employee. So I'll get into that. I think we'll get some clarity on this as we go through the next couple of slides.
Okay, just one more question I think might be relevant. So when it comes to nonprofits, 501c, 6 associations, or we're looking at sole proprietors, corporations, all of these laws pertain to all types of business. Is that correct?
That is correct. And I will say that I reached out even to my legal counsel to see if there was any kind of exemption for nonprofits or businesses like that, and unfortunately, there is not.
Okay, well let's go into the nuances and examples, and then we'll save the other questions for the end.
Okay, let's do that, and we can also answer them before the end if we need to clarify something. So before I get into some examples to have you work through, I wanted to talk about a couple of recent cases that have happened since April of last year. Of course, because whenever anything new comes out, it's always being tested, right? And there's going to be case law that's going to help clarify what the Supreme Court meant, by this new test. So recently, Curry versus Equilon Enterprises, a California appellate court offered some relief to employers by holding that the ABC test does not apply in a joint employment scenario in which the worker is officially employed by a business entity such as a corporation or an LLC, but provides service as a leased employee or contractor to a different party. So this is important. Because, and let me get the next bullet up here too, what it's saying is it suggests that a company that contracts with another for labor will not be deemed as the employer of that worker under Dynamex as long as the employees are treated as employees and are paid on W-2 basis by that staffing company. So let me give you an example. So my company, Affogato HR Consulting, you hire me and I assign one of my consultants to work with your company, right? And maybe they're going to be working with you and they're on site, 1 or 2 days a week. As long as you are working with me. I am a LLC corporation, and these are my employees. I pay them on a W-2 basis. So you don't have to worry about the ABC test if you are working with a corporation that is paying employees. Now, if I sent you someone who was 1099 for me to work for you, we might have a problem with that, right? So there are ways to, really think about, where this whole thing really gets, where you get into trouble is often when you're working with the solo, independent contractor, right? The one person who hung out a shingle and they're a contractor. If you're working with a corporation, all right, that will limit your liability, right? Because the corporation, as in Affogato, is paying those employees as employees, right? So this was just some clarification that provided some relief. It may apply in some situations, and in others it may not. But so that's something to consider when you're thinking about working with a contractor as the owner of the business or the employer, that you might want to look at working with an agency or a bigger kind of outsourcing operation versus working with an individual. The next case was Garcia versus Border Transportation. And this is saying that the ABC test does not apply to claims that do not arise under wage orders. So what's a wage order? I hope any of you that have employees, you should know this, but if you don't have employees, you might not know. Wage orders in California explain and provide wage, hour, and working condition requirements for specific industries. They're regulated by the Industrial Welfare Commission. There are 17 of these, and these wage orders for your industry must be posted in the workplace along with other required compliance postings. And these wage orders just cover things like pay, minimum wage, overtime, maintenance of records, reporting, pay, work breaks, things like that. So if it's only things that are around wages. So if somebody had a claim like wrongful termination or some other kind of claim, it is not, the ABC test does not come into play. So that's a little, relief that we get from some of these cases. And I think this will continue to happen as this ABC test is tested, right, in the real world, that we'll get some clarification, right? But for now, we have to approach this like this is what it is. And, you need to understand your risk and you need to be, approach it very conservatively. So I'm ready to move on to a couple of scenarios. If you are ready, Joy, to follow me with a poll. So let's begin. So our first example: Company X runs an HR consulting business, but does not offer standalone employee handbook project work. Company X identifies an independent contractor who provides standalone employee handbook services. They offer these services to other clients. They have their own tools and templates. So, should Company X hire this person as an independent contractor or an employee, or neither? So let's launch the poll, Joy.
All right, you guys, we're testing the ABCs. All right. And in the poll, we are going to say that Jennifer is the one who wants to provide the, and
okay.
that's fine.
That's fine. So Jennifer is our
so
contractor.
Contractor or employee. Either one is fine or not sure. All right, I'm gonna give you one more moment. Anyone else want to chime in? Okay. And here's the results.
All right. So 69% of you say that it would be okay to make Jennifer a contractor, and 23 an employee, and one of you is not sure, and that's okay too. All right. So what is the answer? Well, the answer is, under this ABC test, Company X should not engage with this contractor because of factor B. The work is not outside the company's usual business. So this is a real scenario, folks. This is my company, and this is a decision that my partner and I made about using a contractor. So we are an HR consulting business. Employee handbooks are part of HR consulting, right? We choose not to do standalone handbook projects. So if we want somebody to do that work, we really need to have them do that work as an employee, because it is not outside of our usual business. So
this Lisa, this factor B is a big one. Can we ask one more question about factor B that came in before the next? Okay. So if you are a marketing company that wishes to hire an independent contractor to do marketing for you, can that be an independent contractor?
So, okay, so that's interesting. I think I know where you're going with this. So if you're a marketing company and you want help with your own marketing, I think that's what the question is, versus hiring this independent contractor to provide marketing services maybe to your clients.
Correct.
So yes, I think you would be okay with that, but I would be a little bit surprised. That would be like me hiring an HR person to come in and consult with me on HR for my business. I'm an HR company. So I guess
here's a scenario. You're a catering company and you're having a staff retreat and you want someone else to cater your lunch.
Oh, well, that would be, oh, I think that would be fine. I think that would be fine. So that's a little bit tricky. I think if you're bringing somebody in to do something for your business because you do not either have the skill set to do it, like in that example of marketing, if you wanted somebody to help you with marketing, but again, it's tricky, right? But I think the more important thing is that with B is that you would not want to bring that person in to be providing those services that your company provides, to clients. So I think you could get away with that, but again, that's it's hard to say. But I think you would be okay if you had a special need and you brought somebody in to do that for your company, as long as it wasn't for your clients. Okay, can we move on?
Yep, let's go for it.
Okay, let's go for it. Okay, example number 2. Company Y runs a massage business. They currently have no employees or contractors, right? So company Y is one person. Let's say she has a massage business. Company Y wants to hire a therapist who specializes in deep tissue massage. Mary is a newly certified massage therapist and is interested in working with Company Y. She has no current clients and she doesn't own a massage table. Should Company Y hire her as an independent contractor or an employee?
All right, this is scenario number 2. And the poll is launched.
Let's go. Ha, I love it.
All right, people are a little more confident in their response to this one. And all right, I'm going to go ahead and launch the poll. End the poll, and here's the results.
All right, 92% of you say they should make Mary an employee, and it looks like we have one person that's not sure. Very good. Mary should not be hired as a contractor because she fails B and C and could possibly fail A if the company directs her schedule. She should be hired as an employee. So that one was a little bit, I think, more clear cut. She clearly didn't meet, most of the prongs and maybe all of the prongs of the ABC test. So good job, everybody, on that one. All right, let's move into our last example, and this one's a little bit more complicated, so we'll challenge you here. Company Z is a technology startup company. They currently have 5 full-time employees. Company Z needs someone to create their website, monitor their social media, and run their marketing department. They would like this person to have a company email address and business cards. John is an independent contractor with his own business. He has multiple clients and has been in business for 10 years.
Wheels are turning.
Wheels are turning. What should Company Z do?
Is John an employee or a contractor? Okay, let's end the poll. Thank you everyone for chiming in there. And here you go, Lisa.
All right, so most of you are saying that John should be an employee, and some of you are saying possibly a contractor. A couple of you are not sure. So, so this is a little bit of a tricky one. And sorry for this big, long answer, but it depends. It depends is our favorite phrase in human resources, because it often does depend. Probably John should not be a contractor. If the company wants him to look like he's an employee of the company, so things like having a company email, having business cards, would look like John would be performing a role that an employee would perform, and issues of control would likely arise. But if we modified the scope of work, we might be able to have John meet the ABC. And this is a very common situations that small companies bring in someone to, before they're ready to hire a marketing department or even a marketing person, to create their website, to set up their social media. This is, a more viable scope of work for a contractor, right? And they could even do that for a period of time. But no business card, no, company email. They would really be going in there to do a very specific set of tasks, and they might do that for a period of time. And is this work outside of the company's usual business? Yeah, it is. They're a technology company. They're not a marketing company. Yes, they need marketing, and it might be a function in their organization as they grow bigger, but it certainly is outside the course of the usual business. So I think the scope as originally presented, not a contractor. But if you modified the scope, John could be a contractor. So there's lots of ways that you can do this. And one final point on this, if Company Z decided to fully outsource their marketing activities to a corporation, they would certainly be okay. There are outsource models for things like marketing, staffing, human resources, where these companies do act as your HR department or your marketing department. But it's a very different model and arrangement. It's more of a vendor contract. And then in that case, those employees of the outsourced group could actually represent the company. They could have a company email. But that's one other way. Again, if you work with a larger organization, you get around a lot of these requirements under under the independent contractor classification. Okay, so that's the end of our scenarios. We could do this all day, but we don't have time, unfortunately. So I'm going to move on to why. Who cares about these worker classifications? Unless there's anything else, Joy, that you think we need to address.
Well, let's just do one. one scenario came up, and then we'll wrap up the webinar with your last slides. But the question is, so a real estate office that manages rentals and hires a person to manage these rentals should be considered an employee, not a contractor.
Yes.
Okay. And they are performing duties that are only for the agency. So yes. Okay, great.
Yes on that. All right, so let's get through the rest of these slides because I know we're getting close here. So who cares about worker classification? Well, pretty much everybody. The federal government, the IRS, the Department of Labor, the state government, the EDD, the Franchise Tax Board, others like insurance carriers and unions. There are a whole lot of people that care about it and that might be interested in auditing your business if you're not classifying properly. And some of the things that can be a trigger for the government, for example, I was in my previous company, we were audited for independent contractors, and the trigger was that we had someone who we had as an independent contractor for over a year, which that was a little bit of a problem in itself, but looked and smelled and felt like an independent contractor when we hired him, had multiple employees, had a business license, and this was, under the common law Borello test. The economy had a downturn, his contract ended, and he was having trouble finding work, and he applied for unemployment. And when he applied for unemployment, the California EDD said that he looked like more of an employee than an independent contractor. And that was what triggered later an audit for our company. So things like that, that's an example of, how you might get audited. It's not like, they're going around, trying to go after small businesses, but they see things like that, and that could put you in a position of an audit. And let me tell you, it is not fun. So you don't want that to happen. So what if I don't want to make somebody an employee? So of course you could make somebody a temporary employee. We talked about temporary employees. You could do that and minimize some of the cost and compliance. But what if you don't want to do it at all? What if you're a solo practitioner and you need somebody and they don't meet the ABC test? One of the things that you could consider doing is using what's called a payrolling or employer of record company. And when you use a company like this, basically the person is their employee. They are the employer of record. The cost is typically about 20% of pay. So for example, if you were paying somebody $20 an hour, you would pay the payrolling company $24 an hour. So it's a markup of 20%. Before that 20%, they do a lot of things. They act as the employer of record. They take care of all the employment taxes, workers' compensation. They have to provide a basic ACA compliant health benefits plan. Most of them offer upgrades on insurance. They offer things like 401k. And it is considered a co-employment relationship between your company and the payrolling company, which basically means that they are the employer of record for all of the compliance, the taxes, everything else, but you get to direct the work of this person as an employee. And this is different than a temporary agency. It's similar to a temporary agency, except in this situation, they would not be providing the labor for you. This would be where you have somebody that you want to hire, but you don't want to set up your own payroll. You don't want to have to do all this compliance stuff. You don't feel that they meet the ABC requirements to be an independent contractor. How else can you hire them? This would be an option. This has worked very well for my company. It's worked well for other clients of mine. I will point out, though, that they do not take all industries. They can be selective about that. And if you are a high-risk industry, like I had someone who has a window washing business and their people are on ladders all day, they choose not to enter into relationships with those kind of companies. So it's not for all companies, but your basic white collar companies, it's a really good option. And then just quickly, do I have to offer employee benefits? You do not have to offer employee benefits unless you have more than 50 employees. And I don't think we have anybody that applies to today. But you can get group health benefits with a minimum of one non-owner W-2 employee. And LLCs can get group benefits as long as one member is enrolled, so you don't even have to be paying yourself as a W-2. It's easy to get these benefits, and they are renewable. And small group medical rates are regulated in California, 1 to 100 employees. So this is just something to consider if you are thinking about hiring employees, but you do not have to offer benefits unless you have more than 50 employees. Okay, and then my last slide is, so if I do decide to have employees, what laws apply to my company? I'm going to provide this as a handout also along with the slides. And this is a chart that has links. These blue are links. This shows what the law is and what size employers need to comply with it. So you see where it's gray, like on the very first one, it applies to any size if you've got one employee or more. And some of these laws apply to bigger companies. So this is just one page of at least a 3-page document. There are a lot of laws. So, deciding to have an employee is, there's a lot to consider because there are a lot of things that you need to do if you are going to have employees. In summary, it's never been easy to make determinations on employee classifications, and you really should consult with an HR expert or an employment counsel if you're uncertain with how to proceed. And in the end, it's really about how much risk you want to take with your business. But California continues to increase requirements on employers each year, and it's unlikely that this is going to change. So, proceed with caution, but in the end, it really is about risk, and risk to your business is something that you really do need to consider. So that's my last slide, and I think we are ready to move into a Q&A session, but I do think, Joy, that we wanted to launch one final poll to ask everyone how they will use the information that they've learned today.
All right. Here it is. How will you use this information? All right. This has been so valuable, Lisa. You've gone into such detail beyond expectations, and I just can see through chat here, a lot of people have been very attentive. We've got a lot of retention on this webinar. So people who attended wanted this information, and you just did a fabulous job.
Oh, well, thank you. Thank you very much. And I am, I'm very happy to take follow-up questions. My contact information will be provided. I know that this is a lot of information. I would be more than happy to follow up with any questions that we haven't had a chance to answer today, or your specific scenario.
So this is quite interesting. I mean, I would agree. The whole planning process, as people are thinking about scaling their business, growing their business, adding new services to their business, having awareness of these laws really helps people make better decisions. So I'm glad to hear that. Next time you hire or contract with someone, absolutely, we're all going to be paying a lot of attention to that, aren't we?
Yes. We are.
And a few people are looking that they do need to make some changes.
Yeah.
So great. So we got a comment, good information. I learned a lot. Do we have ABC employer record company? And what is this? Do we have AB equals N, employer of record company in Siskiyou County?
So what's interesting about these companies is that they don't have to be local, and I will be happy to provide a couple of recommendations of companies that I've used, because everything is done online. I have 2 companies that I've used in San Diego that have done a great job for this. So I can also provide that those 2 company names and websites with the materials that we send out.
Great. Another question about salaried employee. can they be part-time? You mentioned a yearly salary, but as long as they are paid the equivalent of 2 times minimum wage, can they be only
Yes,
part-time? Yeah.
absolutely. They can be part-time, but they have to be paid 2 times the minimum wage times the number of part-time hours.
Okay. Whoops, that's me.
Oh, that's the alarm that we've reached our hour.
Yeah, we're there. So I want to thank everyone for joining us again. Lisa, bravo, bravo, or I should say brava, brava.
Thank you.
Yeah, we really appreciate it. Thanks from Joe, who was one of our co-sponsors. And yeah, if you want to go ahead and hit the last couple of slides, I have a few announcements.
Oh yeah, we have to finish those slides. Okay, here we go.
Okay, so first off, I just do want to say that yes, we're going to send you all the replay, link to the handouts. So that's coming your way. You'll get those tomorrow. And then upcoming events at the Women's Business Center. There is in Reading on May 21st, the next We Thrive. It's about creative planning for business and life. And our next webinar on the 29th, it's quite a different subject. Voice matters, how to unleash your presence as a speaker to grow your business.
Good one.
So that's going to be a lot of fun. And I have met with our presenter and she's great. So, all right. Thanks again for joining us at the Women's Business Center. Thank you to the SBDC and West Company. Please stop by and visit us if we can be of assistance and support you in growing your business. All right, there's our sponsors. Yay!
Yay! Thank you.
All right, Lisa, thanks so much.
Oh, thank you for having me today. Thank you, everybody, for your participation, and I look forward to seeing you on another webinar.
All right, great. Thanks, everyone. Bye-bye.
Okay, bye-bye.